Hello and welcome to the 121% podcast. My name is Kevin Johnson here from Century 21 Edge in Orlando. Today we are welcoming back to the show for, I think it's the third or the fourth time, the legendary Andrew Doyle from Seibane.
Love that introduction.
Right?
The legendary.
The legendary. From Seibane Doyle right here in Orlando, Florida. They are a business, real estate law firm. If it involves dirt, paper, or money, I love that. You've got it covered. TM. Trademark. Excellent. So welcome, Andrew.
Thank you.
How are things going for you today?
For me, it's a fantastic day. For the rest of the real estate industry, I don't know. I think everything's kind of up in the air right now. A lot of people are confused. They don't know what's happening next. But my day's going great. It's Friday. I'm psyched.
You know, as I told everyone, if I had to pick a headline for our agents, and today we're going to be talking about the NAR settlement, the headline would be, everything's going to be okay, right? I actually thought the results of this, and of course DOJ's not done, but I thought it was going to be far more impact to our business rather than how it should be anyway.
What was that show? Keep Calm and Chive On or something
Keep calm and carry on.
Yeah, what was that show?
I thought that was a saying from the British during World War II.
Oh, maybe.
Or World War I, one of them.
Maybe. It was on a show, but I think that's the mantra here is just keep calm and carry on because the industry will survive. Things will continue. Commissions will still be paid. But, maybe that's a spoiler alert.
That's the thing is it drives me crazy. So let's go ahead and, reason why I wanted to do this show with Andrew and reached out to him was that I've been looking over the media, looking on YouTube, watching social media, and we have agents that they're losing their minds. They're going crazy. We have the media, the mainstream media, and they're all guilty from both sides of the spectrum, right, of just completely false headlines. Headlines not based in any element of fact as it relates to the settlement that we're going to talk about today. So I thought it was important we came in and addressed the fact versus the fiction and take the sensationalism out of it. It's like I said, I think it's much better than I was expecting it to be. I think, okay, and it was my first reaction was, this is what everybody's freaking out about? Because I actually read the settlement, which was, whoa.
Bless your heart. It was 108 pages long. Yeah, I skimmed. But, it's literally been fake news.
Yep.
Literally been fake news. From when the settlement was announced, I think it was last Friday morning, about a week ago.
A week ago today.
All throughout the weekend, it was headline after headline. The commissions are going away. NAR walks back 6% commission requirement. And, I'm sure we're going to cover that.
Oh, yeah.
But just so everyone knows, there was never a 6% standard requirement set by NAR.
Or anyone else.
Right. That total commissions on a residential transaction across the United States be 6%, not $1 more, not $1 less. That was never a commission. In fact, that would literally be price fixing, and these NAR suits would have not taken 50 years to be brought. They would have been brought a long time ago.
That's my favorite. Most of the headlines, if true, NAR would be admitting an agreement with a court to break the law in the future.
Right.
Yeah, not happening. So the settlement, the basics of it, NAR agreed to a financial sum of $418 million.
Over 4 years.
Over 4 years, right? They got to make sure they can collect those dues to get that. And then they also agreed to some other items we're going to talk about today. But the big thing is the court has not approved this yet, right? They're not expecting that to May?
I'm not sure when they're expecting it, but it's pending court approval. So when you have a case of this magnitude, you can't just say, okay, we reached an agreement, we're settled. It requires the judge's approval. And this kind of goes back to the type of things that the plaintiffs, the sellers in this case, were looking for. Not only were they looking for monetary damages, but they were looking for structural relief. And these type of antitrust cases, when they're brought, right, they're brought for two reasons. One, money. Two, structural changes. So we see these cases commonly with banks, right? And it results in banks reforming the way that they do business. So here we're seeing NAR settling and agreeing to reframe the way that they do business.
Yeah. And again, we'll talk about, I don't think it's that earth-shattering. It's really...
It's not.
It's if I'm being honest, it's how it should have been. It's actually how it was done in the past, and then we got away from it in the digital age. right? We used to do, as an industry, formal buyer consults, have them sign buyer broker agreements, right? That's how we did it back in the day. And we just got lazy as an industry, right? Not us, but as an industry, we got lazy. And that laziness and that lowering of standards of membership, in my opinion, has led to where we are today. I
mean, I don't want to speak for all agents, but I do think as of late, and by as of late, maybe the last 10, 15 years, it's a little uncomfortable for them to have conversations with buyers about signing buyer-broker agreements. But if I recall correctly, in NAR's settlement statement, their kind of press release, so to speak, they even said, we've always kind of encouraged this.
They have.
And I know that in my practice, I generally recommend to the brokerages that I represent, you should have your agents train them on the forms. Here in Florida, they're called the EBAs, and then they have different forms depending on the single agent or transaction broker relationship. But there's a form for that.
There is.
And it's not that hard. It's not that complicated. It should just be kind of part of the overall agent training, because at the core, that's the agent's job, is to close transactions, and you need to know how you're going to get paid.
As a brokerage, we've always strongly, like in the most strongest of terms, encouraged them. Starting last year, we required them. It was if you're going to work with a buyer, you have to have it before showing a property, full stop. Otherwise, you're not working with a buyer. So for our agents, that one change of the two big ones, if you will, that's a nothing burger for our agents, because we've been doing that.
Right.
So that's so let's talk about the first one. Like you kind of already brought it up, kind of the fact versus fiction. One of the big headlines we keep seeing over and over again in various forms is NAR agrees to cut commissions. NAR agrees the 6% commission model is gone. Let's talk about some of those misconceptions. Like, to my knowledge, and there's never been a fixed rate. And NAR was formed, I think, in 1913, and since its inception, there's never been a fixed rate. In fact, if you look at the statistics, the average, if you just take the average of the total commission charged by both sides, right now, obviously, the average hasn't been at or above 6% for 27 years, according to NAR.
Really?
27 years. So if that's
crazy. So it's actually come down.
Yeah, the average is closer to 5%.
Okay.
If you add both sides together, but that headline's also misleading because it makes it feel like every agent was making an average of 6%. And then let's just say if you're using an average, and we weren't going to use the fake headlines, that's not the case. It's both agents involved in the transaction. That's half of that. So the actual average agent commission is below 2.5%.
Did you see the video I posted on our Instagram page about this?
Yep.
So if you haven't already, please give us a follow at Orlando Lawyers. No, I did a video on this on Monday, and I specifically addressed these things. But the point, I think the most salient point in that video was, these are headlines in the middle of an election year.
Mm-hmm.
And we're seeing, regardless of what aisle the source is on, CNN, Fox, they're all saying the same thing, right? And that's because they need to have the attention. So the call to action, so to speak, from that video was sellers, buyers, agents, brokers, whoever you are, take this information with a grain of salt, because it is verifiably false, but beyond that, consider the source. And I really can honestly say that since the settlement terms were announced, I've spoken to a lot of my clients about this, and everyone is coming to me and saying basically exactly that. Is it fact or fiction? Mm-hmm. And I'm like, this is a complete fiction. There was one instance, and in fact, I think Housing Wire had posted a story on this. There was one instance, and I want to say in the 1980s or so, where NAR was involved with an FTC issue that resulted in some form of fixed compensation, but it had absolutely nothing to do with the issue that we're dealing with now. And there was a Supreme Court decision. Okay. It's a non-factor now.
Right.
So at the very least, it's verifiably false it's verifiably false to say that in the past 25 years, they have not required any sort of fixed percentage commission at all.
Right. And the other thing is, commissions have always been negotiable.
That's the key.
Right. And I can tell you, out of the hundreds and hundreds of deals that we have been a part of as a brokerage, there has never been a seller who didn't negotiate. Mm-hmm. And there's a huge difference, though, I tell our agents, between it is negotiable, but for each of us as a professional, based on our skill set and our history, we're going to have a minimum we're going to charge to do our services, like anybody would. Any profession, an attorney, a surgeon, whatever, you have your minimum. What is it going to take for you to get out of bed and go to work that day?
Sure.
Right? But commissions have always been negotiable, and that nothing is changing before or after. And I hear like, sellers and buyers now get to negotiate their commissions. Yeah, you sure can, as you always have.
The last time we talked about this issue was, I think, November, right after the announcement of the Burnett-Sitzer verdict, the blockbuster $1.7 billion, right? Where's the world going? The sky's falling. In that recording, we addressed that specific issue as well, right? And again, public service announcement. I can't believe I have to repeat this. Yes, commissions have always been negotiable. Listing agents sitting there across the dinner table with sellers, those sellers have always had that right to say, look, I get you want 5% total commission. I'm committed to not giving you a dime more than 3. And if you want to take that 3 and divide that equally with the buy side, that's up to you. But I, out of my pocket, am not losing more than 3% of this purchase price to total commission. That has always been something. The problem is that sellers, I think partly because of the lack of transparency in the industry, I think sellers have never really felt comfortable exercising that right to negotiate. And I really think that lack of transparency is what brought about all of this litigation.
So what do you talk to me about? Because I couldn't disagree more. I think there's been, at least in the transactions we've been involved in, there's always been the transparency. Like they knew they could negotiate.
It's a corporate decision from the top down that has to trickle down through the training to the agents. But I don't believe that the average real estate agent sits in front of a seller and says, look, this is 6%, and this is why it's 6%. And more importantly, the 6% doesn't go to me, just me. That's 6% that you're paying the list side brokerage. In turn, when we advertise your property on the MLS, there's a field there, and we're going to offer to take that 6%, and we're going to divide that with whoever brings a buyer. That conversation doesn't generally happen. And because it doesn't generally happen, we end up with Sitzer and Burnett, Morrill, Batten, Gibson, all of these massive cases that have been filed across the country that really say, well, sellers didn't know that, or they felt compelled to just agree to that. They weren't given any meaningful choice, for lack of a better term. So I do think it's a training issue that's kind of endemic to the industry that hopefully we'll see change now.
And that's one of the big things I've said that, with respect, this is my personal opinion, that NAR has contributed greatly to our issue in that the standards are light. And NAR's goal is membership.
Yeah.
Membership brings money. Membership brings power in Washington. But also, if you increase standards, if you increase the dues to level it up, you decrease membership, which means you lose power, you lose money. Sure. And so there's that battle that is going on within NAR and has been for years of, what's the balance of standards versus membership. And as long as that's the battle, I think we're going to struggle. You're going to have people like this that are going to file suits and try to force the industry to level up. And, for us, I mean, we've always done that at our brokerage and our brand. I applaud our brand. The training I've received from them since joining them in 2014 has always been the same. Right, they're big on the law, follow not just the letter, but the spirit of the law. And if you don't, they will kick a broker owner out faster than your head will spin. They would rather have integrity over the money, and that's what I love about our brand. The next factor of fiction: offers of compensation are going away. So to reiterate, as Andrew said, if a seller lists a property for X%, we would then, as a listing broker, offer a portion of that to another agent that would bring a buyer. That was called the offer compensation. That money came from the listing broker's commission, not directly from the seller. So if I brought the buyer as well, I got to keep the entire lump of the commission, right? So I'm seeing a lot of news stories that are saying that's going away. And it's just not the case. The little field and the MLS is going away. That's it.
Right. Yeah, it's just being moved off of the MLS. And my kind of legal instincts lead me to see that as the structural change that the sellers in the plaintiffs in Sitzer were looking for, because of the NAR requirement that the field be there and offers of compensation be placed on the MLS. Remember, up until I think it was like November 14th here locally, the local MLS had a rule that said that you had to offer at least $1.
A whole dollar.
A whole dollar. A whole dollar. But that was walked back, and I think don't quote me on. Actually, no, quote me. I'm confident. It's November 14th, 2023.
I don't remember the exact date.
That
but
I think
November.
the new MLS rule change went in, and now all of a sudden it was zero, right? So now we're saying, okay, we're going to delete the whole fields. Nobody got all up in arms with the change from $1 to 0.
Oh, they did. Just not as loud.
But yeah, I mean, the fact remains that commissions can still be paid. They can still be negotiated. It's just not going to be on the field. And I think the reason for that is that was one of the prior requirements. And now to make the sellers happy, NAR said, okay, fine.
The funny thing I found in the settlement is that it's explicitly called out that sellers can still offer credits or concessions to buyers. Yeah. You just can't call it for, it's for the commission. You can call it whatever you want to, so we can still offer it there. It can be negotiated off MLS. And by the way, the negotiating deal by deal off MLS is how commercial has been done for years. Mm-hmm. And it's working just fine.
Yeah. I don't see how, NAR can't tell a seller what concessions the seller is choosing to give or not give to a buyer anyway. You want to give a $10,000 roof credit without going through the hassle of re-roofing the house? Go for it, right? Now it's just the same thing. Now, my question, this is really a question for the state of Florida and the joint commission between the Florida Association of Realtors and the Florida Bar, is what changes, if any, will we see to the FAR Bar contract and the CRISPR contracts that accommodate that in Section 9 closing costs?
Well, there was an email that came out about an hour and a half to 2 hours ago.
Oh, I must have missed that
from Florida Realtors that they are working diligently on new listing agreements.
There you go.
A new compensation agreement and new purchase contracts.
That's fantastic. That's great news. I've actually put the feelers out there too. I'm trying to get in contact with some attorneys that sit on the joint committee, so that maybe, just maybe, fingers crossed, I can be a part of that decision.
That would be awesome. Have some sanity there. So just saying. The ruling says, and I'm going to quote it specifically: buyers agents must find alternative ways to be compensated, potentially directly by their client or their customer through seller concessions or negotiations off MLS. So again, the only change to the offer of comp, the only change is the little bitty field, which most agents in Florida don't know how to fill out properly anyway, it is going away.
No.
Which I'm more than happy about. So no big change there. We can't make those. You can't. And also wanted to make it clear in the settlement, we can't make those offers in realtor remarks or anywhere else. They can only be made off MLS.
Right. I've heard recently some people thinking a little bit outside the box and saying, okay, well, what does off MLS mean? Does it literally mean not in the MLS sheet? What if there was, for example, maybe an AI assistant that was keyed into showing time, and the AI assistant was auto-generating details about the property and included in that message to the buyer's agent who had just scheduled something, seller is committed to X percentage on the buy side? Does that constitute an offer of compensation on the MLS, which come mid-July would be basically a violation of local MLS rules?
My creative solving is, right now we include attachments with the listing. Well, what if we have a Dropbox file that, and we put in the realtor marks, here's your Dropbox link for this listing with the disclosures and all that, and in there is a commission agreement.
Mm-hmm. I think we need to wait until July and see what the rule change is as a result of this settlement. And I'm going to call it proposed settlement because it hasn't been confirmed yet. Yep. This is proposed settlement. I think we need to wait to see what the court make sure that the court approves the 108-page verbatim settlement agreement, and then see what that rule change is, and then see how the local MLSs adopt and incorporate that rule change before we can say this is good, this is not. But between now and then, there shouldn't be any significant change. It should be business as usual.
That's why I keep telling people, like, I've had questions from agents already, like, well, what if this? Like, right now, don't worry about anything.
Mm-hmm.
The court has to approve it. I've heard May is when the judge is supposed to review it. And if he approves it as is, as you said, it's not going to go into effect until mid-July at the earliest.
Mm-hmm.
So there's time, and everybody's working behind the scenes to make sure that we're ready. That said, like for our brokerage, we're ready already. I mean, we've already been doing BBA. It's done. Right? That's standard practice for us.
Yeah.
And they've already been, so it shouldn't be an issue.
I do think brokerages that have not yet incorporated the EBA practice or the BBA practice into their training programs, they're going to be at a disadvantage here. And it's really incumbent upon the brokers, the supervising, the managing brokers to say, okay, look, I avoided this issue for long enough, but this is a threat to my financial existence now. So I need to start incorporating this into the training programs.
I'm in the process of writing a class for the school. That
Wonderful.
will be, not just how to fill it out, but also how to pitch it and some scripts with that. Our next one, I love this one, and I've seen a lot of this reading the comments in these videos and news stories out there. NAR settled. Clearly, that means they were guilty as charged, right? Mm-hmm. They knew what they were doing was wrong. And of course, to be clear, as a part of the settlement agreement, NAR has said that they're admitting no wrongdoing. Mm-hmm. But talk to me about that. I mean, from not maybe specifically this case, but you've been involved in cases where there has been settlements, and why would NAR settle a $1.78 billion
for
case
25 cents on the dollar
that had treble damages?
I can give you 700+ million reasons.
Well, that had
why.
treble damages, right? That because it took it to 5.8 billion.
1.7. Yeah, it would have been way up there.
Right.
I believe that verdict alone would have been sufficient to bankrupt NAR as an industry and probably a couple more of the co-defendants.
Well, keep in mind too, there's 87 now additional brokerages out there that are not included as part of the settlement, because only brokerages that had less than $2 billion in revenue last year were included. So there's a lot of big independents out there like EXP, Fathom, some big ones, right, that are not included, some local companies as well, that they still have to figure out their settlement. Today, Compass did announce that they have settled. So they were the largest of the not included ones.
Boy, I spend an afternoon working, and I miss everything.
Well, that's why I'm here.
Yeah,
I'm here to help you.
Thank you.
Yeah,
Thank you for keeping me on track here.
That's what I'm here for.
Let me make a note of that.
Yeah. So, and then of course the big ones, the big ones, Anywhere, which includes Century 21, Coldwell Banker, Better Homes, and several others, Remax, Keller Williams, all settled prior to, at various points during this, right? Before the verdict was Anywhere and Remax, Keller settled after verdict, leaving just NAR and Home Services, and now it's just Home Services left of the original plaintiffs. So yesterday, the plaintiffs also demanded some of the money, or the final judgment, to get the money from Home Services for the entire thing.
Yeah, probably because it's considered joint and several.
Yep.
It's rough.
Yep.
Okay, so to your point, your question about NAR must have been guilty as a headline, right? So one, I take issue, nitpicky, legal, geeky reason here, but I take issue with the use of the word guilt. This is not a criminal case. There's no criminal element here. So in civil, there is no guilt. It's liable or not liable. You're paying or you're not paying, right? So strictly speaking, NAR has not been guilty of anything. I don't think that they ever were in a position to possibly be found guilty of doing anything. Now, to my knowledge, there are some DOJ investigations going on which may result in criminal liability, but strictly speaking, in terms of Sitzer Burnett and the NAR settlement here, there's no guilt. Beyond that, right, there are a number of compelling reasons why a corporate defendant or an individual defendant would settle a lawsuit. And we could talk about settlements for cases that are $5,000 all the way up to $5.7 billion. Right. There are a number of compelling reasons why someone or something or one party would enter into a settlement agreement. It usually has something to do with what I call in practice the law of diminishing returns. You may fight for so long to win, or I should say your lawyers will fight for so long to win. And victory may be on the horizon, but because of the procedural rules and the nature of litigation, it may take so long to get there that the cost of achieving that victory is less or is greater than it would be if you had just cut your losses and agreed to settle right now. Put another way, where was NAR ever going to go with this, right? There was a jury verdict finding liability to the tune of $1.7 billion. If there was no settlement agreement and NAR just said, okay, we're going to let it, we're going to see how this plays out. I think they had a pending appeal, right? So
they did announce yesterday they did not have the ability to put the bond.
Okay.
So that was one of the factors that went into settlement.
So that's what's called a financial constraint on litigation, right? They didn't have the money to fund the litigation, to fund the fight any longer. So it made sense then for them to settle at 25 cents on the dollar, which $418 million is a lot of money, but it's a drop in the bucket compared to $5.7 billion, which is what may have happened had the judge exercised his potential discretion here and trebled or tripled the damages, which is a possibility or was a possibility under the Antitrust Act that they were sued on. So there was a jury verdict. That was it, right? Liability was found. I guess the question posed then to NAR was, okay, where do we go from here? Do we appeal at X dollars, or do we just reach an agreement here and make some changes and pay 25 cents on the dollar? I don't disagree with that decision.
Over 4 years, too.
Yeah. I don't disagree with that decision in a vacuum. Obviously, I don't represent NAR. I don't know what the inner workings of their legal strategy was, but from the 10,000-foot view, sounds like a deal of the century to me.
The one thing that Kevin Sears, the head of NAR, released yesterday in his video was that one of the reasons they chose to settle was the only other path really was going to be bankruptcy. And had they done that, it would have left all the brokerages under $2 billion in revenue exposed. So this protects them. We were, Century 21 was already protected by the Anywhere settlement, so we were good to go there. But unfortunately, they couldn't get those above $2 billion included. But there is, my understanding, a formula involved. If they want to pay, they can pay to get out of this.
Sure.
So, but yeah, I mean, it's a business decision, not so much any other type of decision.
I mean, I represent businesses and I represent parties in litigation all the time, and all of these conversations that attorneys have, and don't ever let anyone fool you, right? You file a lawsuit, your goal is never to take that thing to trial. Your goal is to extract as much as you possibly can, whether it be this sort of structural relief in a non-antitrust case, it's usually called equitable relief. You're looking for conduct, or you're looking for money. But the law of diminishing returns to an experienced lawyer, to an honest lawyer that's not looking just to build a file and is looking to get the job done in the client's best interest, is always cognizant of the cost to the client juxtaposed against the most likely settlement terms and how quickly we can get to the point where we can settle that. In my practice, I call that balancing practical versus principle. In principle, sure, this guy may have wronged you, sue him, but keep the practical in mind. How much is it going to cost for you to get that day in court, and is it really worth it when you win?
Right.
Because who knows what's going to happen. Yep. In settlement, you have control. In trial, look what happened in Missouri.
Yep. And how long would it have taken, say they could appeal, how long would that have taken to...
Probably years.
And left the uncertainty in the industry. And then also, this stops some of the other cases from moving forward. My understanding is that it absolves all the seller-focused cases, but there's still the buyer-focused side that's still out there. So that's not included in any of this, and that's still ongoing. So who knows where that's going to be.
Yeah.
I don't understand the buyer's claim to this at all. From the buy side.
Was it Batten 1? I think it was Batten 1 that was initially filed, and it was met with a pretty stiff motion to dismiss at the early pleading stage. And if I recall correctly, the judge said, "What are you complaining about? The sellers paid your commissions," which I took issue with
Right, because they're not.
Because they're not technically, but that was the analysis was, well, the sellers are paying the commission. Where's your claim here? And now that I'm reaching back to it, I think it was the way that the plaintiffs, the buyers, analyzed it was, well, indirectly. It was an indirect loss.
Well,
so I think they had to amend their complaint.
Their argument, my understanding, was also the elevated home prices, which, again, that's our next factor of fiction is, home prices will fall as a result of this.
I have some opinions on why they're not going to fall.
I would love to hear them.
Okay.
That's why it's on the list here.
So let's imagine, right? Let's imagine a scenario where you're a listing agent and you take a listing and you take it for 3% because that's half of the fictitious standard of 6%, right? Like that's where you start. Anyway, so you take 3%, right? And the buyer comes to you unrepresented. That buyer doesn't have the Bluetooth app on the phone to open up the super lockbox, right? Doesn't have MLS access to get the key code. You need to do the showing, right? So I truly believe that unrepresented buyers will actually secure the 6% total commission more quickly than any direct rule would, because I think it's going to cause listing agents to work more.
Yep. It would definitely will. Like one of our agents asked yesterday, we did an internal town hall. It's like, so does this mean when this goes into place, if I list a property, I'm going to have a bunch of phone calls from agents who are just asking how much money we're offering? I'm like, yep.
Yeah. But I mean, in my example, right, we have an unrepresented buyer.
Yeah.
And because they can't afford to pay out of pocket their buyer's agent, and in our hypothetical, we have a seller that's not offering any sort of compensation. Okay.
And who's going to write the contract?
Exactly. Listing agent has to open the door. Listing agent has to do the showing. Listing agent has to prepare the contract or run the risk of the buyer submitting a form from New Hampshire on a Florida property, right? And then you can't let the seller sign that, so it has to be redone, The communication, all of the things that keep residential and commercial, but we'll talk about residential primarily, residential transactions going forward, this professionalism, that may end up actually securing that 6%. Why? Because what is a listing agent going to do after they get burned a couple times on transactions? They're going to say, I can no longer take a listing at 3% because the amount of work is so much more than it used to be. But the difference is, at that time, that's the market. That's the market dictating prices.
Well, my thought was, you're going to have, right now we have it, here's the total commission I'm charging you, Mr. Seller, and of that, we're agreeing that I'm disclosing to you, I'm going to offer this percentage, half of X or 40% of X or whatever to a buyer's agent. I see a point where we get to, this is what I charge you if there is a represented buyer, and if there's an unrepresented buyer, here's what I charge you, because now I'm going to have to do.
So some attorneys in certain specific practice areas, they have a certain fee that they charge based on filing a lawsuit if there is a response from the defendant. In other words, they'll file a lawsuit, and if the defendant does not respond and they get a default judgment, that's it. You don't respond within 20 days, you get a default judgment, case closed. There's just a few additional pieces of paper you have to submit, but by and large, you win. No opposition. So that fee is necessarily less in the practice of law than it would be if it's an opposed form of litigation. There's the analog right there in the practice of law. I see no reason why it wouldn't also show up in residential real estate.
I also think we're going to start seeing a la cartes, have it, here's my fee for my services, Mr. Seller, but if an unrepresented buyer comes and there's additional this, I have to help them, here's these additional fees that I will be charging you. And then also making sure for all these poor buyers that they're going to be signing no broker agreements, right? That says, I don't have a duty of confidentiality. I'm not, you tell me anything, I'm going straight to the other side, right? There's no loyalty. There's no obedience. Like I keep using the analogy, if you were charged with murder and you didn't do it, you were completely innocent. You show up for court, judge in front of your prosecutor to your side. Judge says, where's your attorney? You know what? I don't have one, but I've been talking with Mr. Prosecutor. He or she seems like a really good person. I'm just going to have them represent me. That's not a good solution, right? And buyers going to a builder or going to a listing agent directly, those people represent the best interest of either the seller or the builder. They don't represent the best interest of that buyer.
I take issue only with the use of the word best interest because that implies a fiduciary duty. So if a listing agent is working as a transaction broker, then they're not necessarily, they don't have that fiduciary duty.
I think I see a lot more single agency to prove value.
Which was where I was going with that,
Yep.
which is another thing that I think is a pivot point for brokerages, right? Brokerage, there are plenty of brokers out there, and I don't even really fault them for this because it's so archaic. But I think a lot of brokers out there don't even recognize that there are two distinct, well, I guess arguably three distinct duties. And then there's the opportunity to jump from one and change the hat, right?
One way,
yeah. And I think everyone is just so comfortable working as this kind of transaction broker, but under the mistaken mindset that for whatever side you represent, you have to act in their best interests, per se. And you don't. At least not strictly speaking best interest, because that implies the fiduciary duty that only exists at least in Florida, right? As a single agent.
Yep.
But I do think that we're probably going to see more single agents because now someone is conceivably paying someone directly for those services the same way they hire a lawyer. So in your murder example, right, if the criminal defendant is paying the defense attorney, then the criminal defendant would expect that the defense attorney is acting in the person who's paying them their best interest.
Yeah.
Right?
So kind of more, I think we kind of talk more about commissions on this one. I don't think commissions are going to fall either. I'll jump back to home prices in just a second because, at the end of the day, if the seller is not offering, buyer's agents are going to charge. Maybe on the buy side, we might see a little drop because a brand new agent going out might not feel as comfortable if they don't have great training and great support, to negotiate that commission to make sure they get it if there's nothing being offered by the other side. But I think on the listing side, if we split it, I think like you're talking about, we're actually going to see an increase in the cost on the list side of the commission. When it comes to home prices, that's not, the other cracks me up. It's like these pundits and these experts saying home prices will fall because of this, that this is artificially held home prices up. If I'm a seller, and I'm gonna say it, I'm being cheap, and I don't want to offer any comp to a buy side, I'm not doing that to then discount the home price. I'm doing it to put the extra money in my pocket so I can pay my agent on the next purchase that they're helping me with. I looked back up just to make sure I was wrong. The definition of market value yesterday. I'm like, I looked over it from USPAP, right? Like, I don't see anywhere in there. This is a national standard where market value is determined based on commissions being paid or not being paid.
Yeah, I mean, it's just a bastardization of the term. That's what it is. I don't see a direct correlation there. I think maybe what they're getting at is the cost of buying or selling a home, right? So closing costs may go down. And again, that's only if the market reacts exactly the way that I think the sellers in the Sitzer Burnett case are hoping it would, which is each side pays their own commission. But the last time we talked about this, I made some predictions that really, I think, go right to the heart of this issue of whether the home prices are going to fall or grow. And I think first-time home buyers may be priced out of the market.
Yeah.
And if you just think back to FHA buyers that are getting approved by the skin of their teeth, they don't have an extra 3%. They already have to put, 3 to 5% down?
3.5%. They can get that gifted if they have a close relative that can do that. But then they're struggling with the closing costs are 3 to 3.5%.
There's always a struggle there. So finding the extra $3,500, $4,000, $5,000 to pay a buyer broker out of pocket, that's going to be a problem. And when you extrapolate that out over the entire real estate industry, you have inventory, but no buyers. So maybe they're right. That's what'll help. That's what'll cause the home prices to fall, is a crash.
Right. The other thing too is
nobody wants that.
As a buyer, right? If I only have the money I need for my down payment and my closing costs, but I want that representation of an agent, I may have to instruct my agent to don't show me houses where the seller is not willing to, cover your commission. And now we have a directive from our customer that's telling us, or a client, depending on relationship, that says, no, don't show me these houses. So from a seller's perspective, that's something they need to consider as well, because that home will sell in the market longer, and then
price will fall.
Price
reduction.
But it's going to fall not because of this decision. It's going to fall because if enough people don't offer that comp.
Yeah, and you know what comes to mind? The saying that my grandmother always used to tell me, penny wise, pound foolish.
Yep.
Right? You don't want to pay that commission, that's fine. You want to put some additional dollars in your pocket, fine. But if you're trying to save $6,000 and you end up losing time off market, the market shift occurs, comps, you get a bad comp in the neighborhood, that could cost you more than the $6,000. Interest rates, right? Or just simply loss of love. Right? Loss of love on the MLS, loss of attention.
Become a stigmatized property because you've been on there too long.
Exactly.
So where do you think, big picture, if we had to look at the future of real estate, I kind of opened up with my headline where it's going to be okay. Everybody deep breath, enjoy whatever libation you enjoy to calm your nerves, but it's going to be okay. What do you think the future? I mean, short term, long term.
So I definitely think things are going to be okay. I firmly believe that in one way or another, particularly here in Florida, we have the Florida Realtors. They're going to spit out these forms, and they're largely going to address this issue. So agents here in the state of Florida, brokers in the state of Florida, there's, just like there always has been, there's going to be a form for that. So that's the first thing, right? Secondly, I do think we're going to see some changes, primarily on the buy side. I think that we're going to see a lot of confusion. I've already begun to hear murmurs and echoes from people about sellers already saying, well, I don't have to pay a commission anymore, right?
Yep, right? We've had one already.
So, the real world, the market participants, the buyers and sellers, they're seeing these CNN headlines, but they don't have the benefit of hopping on an industry podcast and getting the truth, right? So this is what it is. So I do think in the short to midterm, we're probably going to see a lot of difficult conversations that buyer agents, selling agents, and listing agents have to have with their prospective customers about this. And I think that brokers are well informed to have good training sessions about how to address that in compliance with the particular brokerage's policies and procedures. Like, how do we respond to this, right?
Yeah, I think we're going to see a ramp up, too, on the brokerage side of more mergers and acquisitions happening. I think you're going to see some more tenured brokers that have been in this for a while. Mm-hmm. They were already getting closer to the end.
I don't want to deal with it.
I don't want to deal with it. I'm just going to say, and we, within the Century 21 brand, I know they had a record banner year of mergers and acquisitions last year. And so I think we're going to see a lot of those smaller companies fold into bigger companies, or even to medium-sized fold into a bigger company to have those resources. I think we're going to see, I think there's going to be just a native drop in agent count. I think you're going to have a lot of the more tenured agents. They're like, yeah, I'm out, I'm retiring. This is the perfect curtain call. I think we're going to have some of the newer agents that joined the industry, during we won't say the word so we don't get, demonetized, but like the big 2020 fun health issues we had, that joined because it was much like order taking at McDonald's, right? You want a home, you want a pool with that? Okay, great. Here it is. Let's go. And now, you see agents that gravitate more towards the buyer side because it's been easier. Mm-hmm. On the sell side, I have to prove my worth. I have to go in and have a conversation and, try to defend my value and prove my value and defend it. I haven't had to do that on the buy side because the buyer wasn't directly paying me. Mm-hmm. Now, if that's a potential that you're going to have to prepare for on every buyer, right? Yeah. That there isn't. So you have to be able to say, hey, if there's no comp, this is what you're paying me. And that's a different conversation than like, yeah.
So that leads me to question, if we're talking about where this is going, right? Are brokers in a position, are they committed to enforcing the terms of the buyer-broker agreements? Put another way, if you're a broker and you're training your agents to sign these, to make sure that these buyer-broker agreements are signed, are you prepared to put teeth to the paper? Are you ready to sue a buyer that bails on that obligation, right? What do you do?
Excuse me, water went down the wrong tube. That's a question I've been myself, struggling with, because no broker wants to be seen as the broker that sues consumers. That's a public relations nightmare.
Right.
But at the end of the day, if a segment of the population, whether it be consumers or agents or whatever, know that from the agent side, my broker won't have my back to get my comp, and then from the agent side, well, this brokerage is very litigious. Yep. One side wants you to sue, one side doesn't like you to sue, right? How do you deal with that? How do you address the cost of that with agents?
It's difficult.
There's a big conversation that's going to have to happen to see, because you don't want to also be seen as buyers that, I'm not worried about it. They're not going to come after me.
Right. Like, fine. I'll sign whatever you want me to sign. I'm never going to pay, and there's nothing they can do about it. They can't keep me from buying my house, right? And I think right now, status of Florida law is that, I don't see a scenario where a buyer's broker can interfere with the real estate contract when the buyer has refused to pay the commission at closing by either bringing that additional sum to closing or something like that. I can't see a scenario where a seller would not close because the buyer didn't pay the buyer's agent commission. I can see a scenario where the seller's like, I don't care. You want to take $6,000 off the total? Go for it. It doesn't affect my net proceeds. I'm signing.
Right. Yeah, a lot of questions in like the lien laws and how they work in Florida and various states. It's going to be state by state, right? Is how can you securitize that buyer broker agreement? Because there's nothing you can attach it to.
Right.
Well, if they buy one, don't pay you, then will the law change? We can go after them after.
That was the thought a couple months ago was, okay, well, no big deal. We can just roll that into the mortgage. But you can't, because that's not part of the collateral that banks securitize with the mortgage. So you can't just tack on 3% to the purchase price and add that to your loan. The property has to appraise at or above the value of the mortgage that's being borrowed. So unless you have that wiggle room, which in some cases maybe you do, right? But I have had some conversations with a lot of lenders, and they said this is a nightmare. Like, if this is the route that it's going, and we have to work a way to add in the buy-side commission to a mortgage, Congress has to change the law.
And the other thing is that the right thing to do for buyers? Because now you're taking a commission and you're financing it at 6-7% for 30 years.
Yep. At now enormous interest rates.
Yeah, like is that the right thing for the buyers?
No.
It's a challenging market for sure, and I think right now there are a lot more questions than firm answers, which is how it's designed. Everybody needs to take a deep breath, relax. Let's get through the court approval. There's also that other little entity, that insignificant Department of Justice, quote unquote, right? That still has to chime in. They're not done with the industry. What are they going to do? Is this going to appease them? Is it not? Because their big thing is they want a complete decoupling where the listing, the seller can't pay the buyer's agent comp, right? So that's what DOJ wants.
Right.
They're not getting that in this agreement. Are they going to be okay with this? And they leave it alone, back off. Who knows? So there's more to come on that front as well. So, everybody just needs to relax. Let's wait for the courts. And then your state realtor board will come out with the forms that you need. I'm assuming all the other states work like Florida, where they provide them forms. I know I was researching different listing forms yesterday, or listing contracts, and even though Ontario, they have their real estate associations, where not realtor, but real estate associations, and they provide forms as well. So it's pretty standard, I'm sure. We need to wait for those to come out, and we'll be fine. Make sure if you're a broker, make sure you have a good attorney on your side, to help advise you. This is not the time to not talk to your attorneys. Make sure you're having an open dialogue with them and knowing what are the impacts of the ruling, of the settlement, proposed settlement, how will they impact your business, and start preparing today.
Yep.
Don't wait until it's time. Start preparing. If you're not using buyer broker agreements, start today. Start mandating that, say, change your policy and procedure manual. If you're an agent not using them, you should be using them. Have those formal buyer consultations. I asked the question yesterday of our agents, would you go take a listing without a listing agreement? Absolutely not.
Right.
I mean, the resounding, no, what are you talking about? That's crazy. That's stupid. But we see agents every day do that with buyers.
Mm-hmm.
Why would you take a buyer without a contract?
Mm-hmm. Why would you drive all around town showing 35 houses to someone without having something in writing?
If they're showing 35 houses, they need some training.
Fair enough. Fair enough.
3 to 5, okay, right?
Did I say 35? I meant 3 to 5.
Oh, that's what you meant. Okay, that works. Yeah, that's better. Any final thoughts before we close it out for today?
No, I just bring it back to where we started, right? Keep calm and carry on.
Yeah.
It's not the end of the world. It's not the end of the industry. The sky is not falling. We'll figure this out. And, we're going to see some rule changes in July. That'll be interesting. I'm sure we'll probably do another podcast on what those rule changes are and how they affect local MLSs here. But it's not the end of the world, despite what the pundits have been saying this week.
And I also think my final thoughts is, as an agent, as broker owners, if you're in this industry, you need to be paying attention to the news. Good or bad, you need to be watching. I was speaking with an agent the other day. He's like, I just don't like the news. I tune it out. I said, I get it, but your customers are. Your clients are. And if you don't know what they're seeing and what they're consuming out there in the media, you're not going to be prepared to be able to respond, right? And make sure, take the time, download the settlement, facts.realtor. You can download their fact sheet, the settlement, everything. Paragraph 58 of the settlement will go through all of the practice changes that they're proposing. Oh, one final thing. Paragraph 59, first sentence. What the beep?
I honestly, I don't know. I've reviewed it a couple times.
Well, share what it is.
Yeah. So
paragraph 59.
The first sentence of paragraph 59 basically says that all of the settlement terms kind of drop off after 7 years, so they expire.
Gone.
So in a really strict reading of that, it seems that the disappearance of the offer of comp fields might result in a reappearance 7 years down the road.
Magic.
I really don't understand it, and I mean, it kind of boggled my mind to see that there. There has to be some reason, but I can't glean it from the document itself.
Yeah,
it's odd.
It is. When you asked me if I'd read the first sentence of 59, I'm going, I'm sure he's referring to the sentence I was like going WTH about, right? But like, I opened up, like, yep, that's the one. It's that one.
It's weird. It's weird. There's probably some, if I had to guess, there's probably some confidential reason why that specific term had to be in there. I don't know. Maybe it's bankruptcy protection. I don't know. But there had to be some compelling reason for one side or the other for why that needed to be in there. And
for why the plaintiffs allowed it.
Right. Maybe it's, look, this is a temporary stopgap measure until we have a more permanent solution. So NAR's offering to give 7 years of this. Let's see how the market reacts. After 7 years, we'll see if the market drives down the average commission.
Right.
Because our position is that no rule that we have ever set out has actually artificially inflated the cost of commissions.
Right. Who knows?
I don't know.
That was a rather interesting one. But anyway, back to what I was saying is, follow the news, follow the headlines, read the settlement, make sure you know what it says so that when a seller or a buyer has a question, you can answer it with confidence. Remember, you're not an attorney, so don't cross that line. But the facts are out there. Like internally, we have a FAQ document we're running, and I preface it, or I worded it as if the seller is asking our agent a question, how the agent can respond based on the facts. Matter of fact, I used ChatGPT, uploaded the settlement agreement, the fact
Kudos
sheet.
to you. Like you have mastered that thing.
Trained it, so it's actually doing out. You can now feed it in a news story and ask it to fact check it, and it's hilarious. Like
That's awesome.
It's nailed it every single time. So it's been kind of interesting to watch it fact check stuff. But so definitely make sure you know the facts. Make sure you know what's in the media, and don't trust the headlines. Don't trust the stories. Fact check everything. Be the expert. Be the calm, cool, level person that's going to bring some sanity, and talk to your customers. Make sure they know what's going on and know the timeline of everything. Don't go crazy. Don't panic. Don't be that agent. Right? There's plenty of them out there doing it for us. Don't be that agent.
Yep.
So, all right, everyone. Well, thank you so much for tuning in to the 121% podcast. If you're listening on your favorite podcast app, please do us a great big favor and make sure you follow us there. Make sure you give us a review. Give us those 5 stars. It helps the algorithm push our podcast out to other folks. If you're watching the video on YouTube, make sure you hit that like button. Make sure you subscribe to us and hit the bell so you can be notified the next episode, when the next episode, I should say, is released. So remember, the 121% podcast, it's the 50% education, it's 50% motivation, but the difference between ordinary and extraordinary is the extra 21%. Thank you so much for watching. We'll catch you next time.